more money than we thought. And Aston University have bought it. Well, universities have money, don't they? So,
I'm hoping you can hear and see us okay. Hello? I've got Lewis and Katie. Are you representing someone?
hello, good afternoon. I'm Louis Stone, solicitor for the applicant, and I have one of the directors here with me.
Hi, I'm Sanjeev, I'm the operations director.
Thank you very much. And Katie, are you representing?
Yes, I'm the DPS holder.
Okay, great. That's fine. I'll just go and get the panel and then we'll begin shortly. Thank you.
Thank you.
Yeah, we'll just do a quick check. No one's in reception. Okay, welcome everyone. For this meeting, could I take any nominations for chair for the meeting, please?
I'd like to nominate Councillor Gore.
Thank you. Is that seconded? Yep. Over to you, the chair. Thank you.
Good afternoon, everybody. Apologies for the late start. I'd like to just highlight some housekeeping for those of you joining on Teams. So please refrain from using the meeting's chat for anything other than indicating you want to speak, and please mute your microphone until it is your turn to speak. So, welcome to this meeting of the licensing panel. I'm Councillor Gore, chairman of the panel today, to consider the application for the Vault High Street Crowthorne. I would like to start by asking everyone to introduce themselves, starting with panel members. I'm Councillor Gore, Ward Councillor for Winkfield and Cranbourne.
Councillor Pennell, Ward Councillor for East Hampstead and Wide Ridings.
Councillor Cochrane for Hanban and Birch Hill. Not very well.
Sorry. Our clerk.
Hello everyone, and I'm Liz. I'm Lizzie Rich. I'm the clerk for today's licensing panel. So I'll be the one taking the notes and everything everyone says, and I'll be the one to send your decision there.
Legal advisor.
Good afternoon. My name is Donald Adams. I'm solicitor. I'm legal advisor to the panel today to help assist on points of procedure and law, and so ultimately trying to ensure that the decision taken is robust and in accordance with the law.
Licensing officer.
Good afternoon, I'm Riley Timney, Licensing Officer with the Public Protection Partnership up in Bracknell Forest.
Good afternoon, I'm Harry Maycock, also a Licensing Officer with the Public Protection Partnership.
Applicant.
Good afternoon. My name is Louis Stelling, Coleridge Law, solicitor for the applicant.
Hi, I'm Sanjeev Lal. I'm the operations director at London Trading Mould.
Thank you.
Good afternoon, I'm Katie Bourne, I'm the DPS holder.
You. And we have another person in the room.
Well, I'm just observing. I'm licensing enforcement officer for West Berkshire and Bracknell.
Thank you.
Chair, we were due to have a number of objectors joining us today, and both had indicated they were joining on Teams, but I haven't heard from either of them today. They have had the link to join.
Okay. Well, we will proceed in their absence. So, item 2 on the agenda is a standard item relating to the declarations of interest. Would members of the panel please confirm they have no disclosable pecuniary or affected interest in the application before us this afternoon? I can confirm that I have not. Councillor Purnell.
I have no disclosable pecuniary, I can't say the word, interests.
Councillor Cochrane.
And I have no pecuniary interest.
Thank you. So item 3 sets out the procedure that must be followed for hearings considered by licensing panels. For the purpose of today's meeting, I will quickly remind everyone of the order which we will follow. First, I will ask the licensing officer, Riley Timney, to present his report in respect of this application. Everyone will then have the opportunity to ask questions of the licensing officer. Secondly, we will consider the objector's case, and this is in terms of the written representation we've had as they are not here. Following that, I will ask the appellant to present their case for why the application should be granted. There's going to be plenty of opportunity to ask questions of all participants. However, all questions must be asked through the chair and there must be no cross-examination. Before we finish, we will confirm that the applicant and objector and the applicant has said everything that they wish to inspect in respect of this application. And at this point, I will ask everyone to leave the room and the panel will make their, or we will leave the room and the panel will make their decision in private. At this point, you're welcome to leave the meeting, or if you want to hear our decision, you may stay and be readmitted to Teams or wherever by the clerk. The panel's decision will also be communicated in writing to all parties within 2 working days and will be published on the council website. So, determination of the application for the vault. The purpose of this item is to determine application for a new premises licence for the vault, High Street, Bracknell. Before we begin, I must ask whether anyone feels there's a reason for an adjournment in this case. Anyone?
No.
No, Chair.
Thank you. Mr. Timney, can you confirm that the formal requirements in respect to this matter have been complied with?
Yes, Chair.
If we are ready, I will ask Mr. Timney, the Public Protection Partnership's licensing officer, to present his report.
Thank you, Chair. Can everyone hear me?
Yes,
Yes.
sir.
And my name is Riley Timney, and I'm the licensing officer with the Public Protection Partnership, and I will now introduce the application. On the 30th of May 2024, an application was received from Rondell Trading Limited for a new premises licence under Section 17 of the Licensing Act 2003. The application relates to a premises located at The Vault, 19 High Street, Crowthorne, RG 457AD. This application has been recorded on the licensing database under reference number 24648. The application was validated on the 30th of May 2024, and the consultation period ran from the 31st of May 2024 until the 27th of June 2024. Responsible authorities were notified of this consultation period on the 31st of May 2024, and neighbour notifications were given out as per the Statement of Licensing Policy of Bracknell Forest Council. The application was advertised in accordance with the Act, and the relevant blue notices were displayed at the premises, and a notice of this application was advertised in the Bracknell News on the 12th of June 2024. A copy of the application form is attached as Appendix 1. A copy of the premises plan is attached as Appendix 2. A copy of the designated premises supervisor details are attached as Appendix 3. The application seeks to obtain the following licensable activities: supply of alcohol Sunday to Thursday from 10 a.m. until 10:45 p.m. for consumption on the premises only. Fridays and Saturdays from 9 a.m. until 11:45 p.m. for consumption on the premises only. Provision of the live music for Friday and Saturdays from 11 p.m. until 11:45 p.m. indoors only. Provision of recorded music Friday, Saturday, 11 p.m. until 11:45 p.m. indoors only. Late night refreshment Friday, Saturday, 11 p.m. until 11:45 p.m. indoors only. A total of 5 representations were received from members of the public. These representations were made in the belief that granting of this new premises licence would undermine the licensing objectives: prevention of crime and disorder, prevention of public nuisance, public safety, and the protection of children from harm. These representations were mainly in relation to public nuisance, with concerns over noise being generated from the premises. These representations can be found as Appendix 4A through E. No representations were made by any of the responsible authorities. However, a comment was made by Health and Safety in relation to the ratio of hand wash basins per WC. This comment was not in relation to any of the 4 licensing objectives, and it is included in the agenda pack as Appendix 5. Following receipt of valid representations, mediation took place where the applicant offered additional conditions and an amendment to their application. This includes the reduction of their opening hours to those currently outlined in their current planning permission for the property, meaning that the opening hours and hours of which alcohol will be sold at the premises will be Monday through Sunday, 12 midday until 11 p.m. As per the Legislative Reform Entertainment Order 2014, the playing of recorded or live music would no longer be a licensable activity in aspect of the premises if this licence was to be granted, as a premises that is licensed for the sale of alcohol is allowed to have live and recorded music until 11 p.m. without it being specified as a licensable activity on their licence. The applicant has also offered further conditions following items highlighted in a representation that there will be a restriction on the disposal of glassware between the hours of 10 p.m. and 8 a.m. Other conditions were that the licensee shall instruct members of staff to make regular checks of the area immediately outside the premises and remove any litter, bottles and glasses emanating from the premises, and a final check should be made at close of business. Adequate waste receptacles for use by patrons will be provided in and immediately outside the premises. The licensee shall provide a safe receptacle for cigarette ends to be placed outside for use of customers, such receptacle being carefully placed so as not to cause an obstruction or trip. Following the above being provided, this was sent to the 5 members of the public who had made the representations. In conclusion, 1 member of the public has withdrawn their representation. This representation specifically is listed as Appendix 4C in the agenda pack. There was no response from 3 members of the public when the amendments were passed on to them. Another person who had made a representation had not clearly stated that they wished to withdraw their representation. As relevant representations were made, members must determine this application. Members must consider all representations, both written and oral, with due regard to the licensing objectives and decide whether an application for a premises licence should be granted or rejected. If members are minded to include any additional conditions other than those offered up by the applicant, they will need to provide their reasons for doing so in the decision notice. Licensing authorities should only impose conditions which are necessary and proportionate for the promotion of the licensing objectives. In addition to this, it is stated that any condition attached to the licence should be enforceable. Thank you.
Thank you, Mr. Tinley. Panel members, are there any points?
Chair, do you just want to, I just wanted to raise the point that we've had an objector join the call. Would you like to introduce yourself?
Is that Mr. Daluta? Good afternoon, Mr. Daluta. I'm Councillor Gore, chairman of this panel. Welcome to the meeting.
Hello, can you hear me, everyone?
Yes, can you hear us?
Yeah, good afternoon. Sorry, I was a bit late. I was stuck in another meeting. Yeah, my name is Vinesh. I live in next door to the new building.
Okay, so we're at the point where the licensing officer has presented the case for the Public Protection Partnership.
Okay.
And now, panel members, there's an order which we're following through this procedure, and I will make sure that you're invited to comment when it's your opportunity. So, panel members, are there any points of clarification you wish to ask of the licensing officer? No? So I'd like to just clarify one point. So in the appendix you referred to, which we've had to consider, the licensing hours are different to what you have suddenly told us about today. So could I ask in future that this information is provided in advance of the panel, so we're able to make a considered judgment on how we approach the situation?
Yeah, the information that was provided in the agenda pack came through, obviously, was sent out in time. These amendments have been made since then, but I will take that on board going forward. Thank you.
Yeah. So now, Mr. Selly, are there any points of clarification or questions you wish to ask of the licensing officer?
No clarification or questions, Chair. No, thank you.
So the Vinesh, you missed the licensing officer's presentation, so it's difficult for you to ask any questions relating to it, I'm afraid. So we'll move on.
Yeah, that's fine.
You may have
That's
some
okay.
comments on what's in the agenda.
Right. Do you do you have any comment on what is in the agenda on the licensing officer's report then?
Nothing at the moment.
Okay.
Thank you.
Thank you very much. Thank you very much. So the panel will now consider the representations from those who have made objections. That's you, Vinesh, your opportunity to give a brief outline of why you have objected to this application.
Okay, my main concern is not about objections, about wanted to find out exactly what's going to be the process, obviously, like when it comes to people picking up their clients or people parking up as well, because obviously I live next door and we don't want like cars to be stacked up in our car park, and also the level of noises as well at the end of the night, having to manage noises level and people leaving the place as well. Because obviously I'm for the company going ahead, because they're going to help with business and things in the area, which is good. But just a little bit that I'm a bit concerned of is noise management and also like delivery of stuff as well. What time are we going to get delivery, and these things is a bit of a concern for me.
Thank you, Vinesh. Some of the questions you raised have been outlined in the report that's been published. Have you not received a copy of the report?
I have indeed received a report copy, but I've been so busy with my work as well. I've not had a good time to sit down and read the report properly.
Okay, so to paraphrase, you're concerned about parking, noise, and litter. Is that correct?
Yes.
And deliveries.
Yeah.
Okay. So, are there any questions from my fellow panel members for the objector? Councillor Purnell?
Thank you, Vinesh. Did you live in your property when it was the previous restaurant, the smokehouse?
Yeah, but the smokehouse was always closed.
Ah, okay.
Yeah,
So
it
I'm
was-
just wondering. Yeah.
Yeah, it was always closed. It was a business, but for some reason it was always closed and open like only once a week, and there was never been.
Okay.
The
When it
triple
was
Bs. The triple
Triple
Bs,
B,
yeah.
that's it. Yeah,
Yeah.
that was it.
Yeah, sure.
When it was open, the days it was open, do you recall any issues then with deliveries or parking?
Obviously, like parking, people used to park in our car park as well, like blocking the entrance. They used to block the car park and difficult to get in. With delivery, I did not see any deliveries coming in as such. But obviously, like, because they were open only a few times a week, and
Okay, thank you.
Yeah.
Chair.
Councillor
No,
Corbyn?
that was my question about the deliveries, actually.
I have one question. Vinesh, can you explain, because we don't have a map of the area, where exactly you live in relation to the back of the premises?
so I live in a crime. Where the process would be, if you look on your left side, there's a small alleyway, and I live in a building on the other side, which is like there's a there is like a funeral parlor as well, underneath where I live.
Thank you.
Sorry, Chair, if I may. I do have a map which shows the location of the premises, and I believe the building where Mr. Daluta resides, if that would be an assistance, if everyone is to agree, I believe would be the way forward in this. But yeah.
Can we see the map, please?
Yeah, does everyone need to agree though? Sorry.
Yeah, does the applicant have any objection to a map being?
No. You can go ahead. Yeah.
I think that could be emailed to.
I'll send it. I'll show it on the screen.
Oh, sorry, it'd be shown on screen. Can all parties see that map?
Yes, thank you.
Yes.
Thank you, Mr. Timley. If there's no further questions from the panel, Mr. Stelling, do you have any questions of the objector's case?
Chair, good afternoon. Thank you. I don't really have any questions of the objector's case, either Mr. De Lasso, who's on, or those who've not been able to join. Other than to reiterate what the licensing officer, Mr. Timney, very clearly laid out in his presentation of the application. I'm not sure whether you want me to go into that now or at the next stage.
At the next stage, please, Mr.
Of course, Chair. Not a problem. Then I have no questions as to the points raised by Mr. De Lasso or any of the written submissions at this stage.
Thank you, Sally. Mr. Timney, do you have any questions or points of clarity of the objector's case?
No, Chair, nothing from me. Thank you.
If we're ready to move on, now's your opportunity, Mr. Selling. Would you please outline your case for granting the application?
Thank you, Chair. As Mr. Timney pointed out, we are now dealing simply with an application that deals with the on-sale of alcohol. The business operational hours as per planning application 19-0029-1-FUL, approved by Bracknell Forest Council on 7th of June 2019, limits business hours from 12 midday until 11 p.m. Therefore, there can be no activity, whether licensable or not, outside of those hours. The applicants, therefore, would simply need a licensable activity of on sale of alcohol between 12 midday and 11 p.m. Despite this, they are, of course, aware and sympathetic to the concerns of local residents. And in that, they would like to extend an invitation to the local authority licensing officer to attend the premises when they put the noise system in, along with the limiter, the limit to which will be agreed with the local authority ahead of time to ensure minimal impact or zero impact, frankly, to those local residents. Quite rightly, if any of us were living next to somewhere that we thought might be incredibly noisy, we would have concerns, albeit it's very difficult to negate those concerns before we have opened. It's still a building site, but we are absolutely prepared to engage with local residents as to that. We completely appreciate their concerns. It would be a licensing condition that we would be happy to have on our license in terms of the noise limit to be agreed with the local authority. The sound engineers would install that. The local authority can, of course, be present upon installation, and that can be inspected, checked, recorded, monitored in any way that the local authority deemed fit. This is a food-led enterprise. This is not going to be a late night club, drinks bar. The concept menu that I've been provided, which we will be happy to pass on, is extensive. It is not a drinking establishment with light bites. It is very clearly going to be a proper restaurant. Again, although it's not a licensable activity in terms of parking, littering, we're very happy to engage. And I think those measures put forward at the mediation stage, I hope, would allay any fears. Clearly, only one objector has attended today, and so I deem it that they have reviewed those and see that they're fit. Mr. Dolata, of course, being a very, very close resident, he is one of those people that we'd seek to engage with. Deliveries is a very tough one because at the moment we're not sure. We don't know what delivery schedules might look like or operational hours of those people delivering to us. But in the same vein, we can only do what we're able by asking them or giving them our sort of favoured times for deliveries so as to avoid 5 a.m. on a Monday morning. Presumably the local residents wouldn't like that. But we are bound mainly by external providers in that nature. And so all we can do is try and be as sympathetic with those residents as possible. I also don't think the applicants would want to be there themselves at 5 a.m. on a Monday morning. So I think interests may align in that sense. As I say, our apologies that the application wasn't reviewed and amended ahead of this. I wasn't the instructed person in terms of making the application, but we have a severely limited application now as opposed to what it would have been. And it is purely the on sale of alcohol to be considered, no other licensable activity at this time, Chair. Thank you.
Thank you, Mr. Selling. Panel members, do you have any questions?
Yeah, if I may, Chair.
Sure.
I know it's not an activity that we are looking at today, not a licensed activity, but could you just explain what sort of music would be played in the establishment? Because there was talk, one of the objectors mentioned a resident DJ that they were concerned about.
Yeah, sorry. Yeah, we're a bit confused about that. There's not going to be a resident DJ. There's never been any advertisement about a resident DJ. We're also clearly there is somebody within the local community who, quite rightly, as residents, and I say we are completely sympathetic to this, has been passing leaflets, pamphlets through saying this is what's going to happen. At no stage have we been approached as the applicant to engage with this, to sit down and talk to these people. There is not going to be a resident DJ. There is going to be incidental background music akin to any normal restaurant. And there had been in the original application for special events, a saxophonist or a violinist or something like that, which of course wouldn't come under this application. Should in the future the applicants wish to revisit that sort of issue, it would of course need to be in line with the opening of the planning hours. So it would simply be music as in any other restaurant or bar, very low-key incidental background music, certainly not a residential DJ.
Thank you. Thank you, Chair.
I have a couple of questions, if you don't mind. So, just from a technical point of view, in your documentation, you say that external doors and windows will be kept closed after 2200 hours. I'm wondering, because having looked at the map of the internal arrangements of the premises, is there some sort of air conditioning facility in place?
Yes, we have internal air conditioning, 3 units.
Thank you. And then just to for our own benefit, you state that there's a policy in place to deal with unreasonable noise. Could you just give us an overview of what that might be?
Initially, there would obviously be the limitation on the sound system, and that, as I say, would be agreed with the licensing officers. We are by no means experts on that matter, but there is soundproofing being putting in. There is a double door at the entrance, and both doors cannot be open at the same time. So that leaking of noise from inside the premises onto the street would be severely limited, nigh on impossible, really. So the soundproofing, the limitation on the sound equipment, and the double doors at the front would all, we hope, ensure that any noise audible is absolutely limited or non-existent. We will also, of course, ensure that there is signage in the entrance and exit to the property, reminding our clientele that we have residential neighbours and asking them to ensure that their noise is kept to a minimum upon exit, specifically towards the end of the evening.
Thank you, Mr. Selling. If there's no further questions from the panel, Mr. Dowluter, would you like to ask any questions you may have? Now's your opportunity.
No question as such, but just want to clarify something. I don't know if there's it was a typo error on the application. The music time on a Sunday is 11 p.m. to 11:45.
Yes, I mean, I think you missed the beginning of this meeting when the licensing officer highlighted that there had been a change to the arrangement now, and now every evening the music or refreshments will finish at 22:45, and the terminal hour being 11 o'clock. So that is a change to the paperwork that you're looking at.
Okay, that's fine. Yeah, I've got no objection, and hopefully I look forward to visiting the place as well and having a good time in the place.
Thank you, sir.
Thank you, Mr. Douglas. Mr. Timley, do you have any questions or points of clarity? The applicant?
No, nothing further from me. Thank you.
At this point in the proceedings, I'll ask the applicant and the objector to sum up their case. This is for protocol purposes. I would ask that you do not introduce any new information or evidence at this stage. So, Mr. Dowluter, can you just briefly sum up your feelings on the matter now, please?
Okay, so I feel like the question has been answered, and I'm happy with the question I've raised. I feel like I'm happy with the place to go ahead, and like I said, I look forward to enjoying a drink and food as in a new place.
Thank you very much. Mr. Selling, can you please briefly sum up your case?
Thank you, Chair. Hopefully with the limitation of the application now in its current format, and with our clients' repeated engagement and ongoing engagement, the panel see fit to grant the licence. As mentioned in my submissions, we are of course very, very happy to work with the licensing department to organise those limitations on the music, to have a site visit, anything that they might require moving forward. Our clients are very much committed to, and we thank you for your time.
Thank you, Mr. Selling. So that brings everyone's contributions to a close. I will ask you each in turn to confirm that you have said all you wish to say with regard to this application. So, Mr. Selling,
Yes, Chair. Thank you very much.
Mr. Daluta,
Yes, Chair. Thank you very much.
Mr. Timney.
Yes, Chair, thank you.
Thank you all for confirming. Before we finish this meeting, I'll ask our legal advisor, Mr. Donald Adams, to advise us of any legal issues that need to be taken into account.
Thank you, Chair. As you've heard, both from the licensing officer and indeed from the applicant, and in answer to Mr. Daluta's query, and in terms of anyone else who may be viewing online or who have made a written representation, by way of clarification, I'll just confirm that essentially the application as originally applied for has changed from what you've heard from the licensing officer and the applicant. So originally the application as per the agenda was to supply alcohol for consumption on the premises Sunday to Thursday between the hours of 10 in the morning and 22:45, with terminal hour being 11 o'clock, extended on Fridays and Saturdays to being until 11:45, with the terminal hour being midnight. The published application also sought a late night refreshment license, which is required to supply hot food and hot drinks anytime between after 11 o'clock. The applicant was seeking such late night refreshment license on Fridays and Saturdays until 11:45. And in light of what was being sought in terms of Fridays and Saturdays, they're also seeking for permission for the permitted provision of regulated entertainment, being live or recorded music, again on Fridays and Saturdays until 11:45. That, however, has been changed. That's no longer the application before you that you are to determine. As the applicant has stated, planning permission has been granted by the planning committee for a proposed restaurant at this premises. That planning permission prescribes the hours of business will be between 12 and 11 o'clock, 7 days a week. As a result, and as there's not currently any application to seek to vary that planning permission, the application before you in terms of the licensable activity has now been changed, so that what is being sought is solely the provision of solely a premises license to enable the supply of alcohol for consumption on the premises between the hours of 12 and 12 at midday and 22:45, 10:45, 7 days a week, with the terminal licensing hour being 11 o'clock. As a result, because everything is going to now finish by 11 o'clock, there's no need for what I just referred to in terms of late night refreshment license, as no hot food or hot drinks will be supplied after 11 o'clock. In addition, there's no need for a license to cover regulated entertainment, the live or recorded music, because none will be provided at the premises after 11 o'clock. And following recent or previous changes to legislation, such live or recorded music can be provided within a premises license up until the hours of 11 o'clock each evening, where that's provided to premises that have patrons of lesser than 500 in number. And as per the agenda application, the proposal is that this restaurant will have patrons of less than 500 in number. The approximate coverage for the covers for the food being supplied is 100. So as a result, just to clarify for everyone watching and all parties interested, so the application is for a premises license to supply alcohol for consumption on the premises only, and that's between the hours of 12 o'clock, 12 noon and 22:45, 7 days a week, with the terminal licensing hour of being 11 o'clock when everything must finish. As you've heard from the applicant, the proposal is that the premises will operate a licensed high-end restaurant serving approximately 100 covers. As per the application and the applicant's operating schedule, which is set out in the agenda pack. The proposal is that we no vertical drinking. By that I mean stand-up drinking, and that alcohol will only be supplied for consumption on the premises and only in conjunction with substantial food orders. As you've heard from the application, this application is primarily to license a food establishment, a restaurant, and alcohol will only be supplied in conjunction with those substantial food orders. As I said, planning permission has been granted for this premises to be able to operate as a restaurant. It's not for you to go behind that planning committee's decision to grant such permission for a restaurant. You are tasked today with determining whether that restaurant can operate licensable activity, namely in terms of the supply of alcohol on premises and the associated provision of live or recorded music during those licensable hours. The decision on planning and the decision on licensing are separate matters. They're separate decisions that come under separate legislation. However, there is an element of crossover. One would hope and consider that when the application for planning permission was granted, they would have taken into account that they, being the planning committee, would have taken into account elements relating to access to the property and indeed parking. It's not for you, as I said, to go behind that planning permission to enable a restaurant to operate from this business. The matter for you is solely to determine whether you should grant a license for the licensable activity that's being sought for at this premises. As the applicant has stated, and as is in the agenda pack, parking itself is not a licensable activity. Your job is to consider the effect of the licensable activity should you be minded to grant the application. As the applicant has referred to, and as the map shows, the proposal is for a restaurant to operate at this premises, and for you're being asked to grant a alcohol license in respect of it. The application does refer to other licensed premises being in the immediate vicinity, and indeed, as you've also heard, this same premises was previously run as a licensed premises, albeit in another guise and by another operator. You were concerned with determining this application in respect of the licensable activity. There are only a limited number of licensable activities under the Licensing Act that you need to consider. One is the retail sale of alcohol, which is being sought. The second doesn't apply because it's in respect of the supply of alcohol by or on behalf of a club. The third and fourth, the third is the provision of regulated entertainment, which for the reasons said no longer applies. And the fourth is the provision of late night refreshment, which, as I've said, no longer applies because nothing's going to be supplied after 11 o'clock. So the only licensable activity that you're concerned with is the retail sale of alcohol, and here for consumption on the premises. As I said, the parking arrangements themselves are not a licensable activity because they're not retail sale of alcohol. So your task is to determine whether granting a premises license for the retail sale of alcohol for consumption on the premises promotes the 4 licensing objectives under the Licensing Act 2003, including as the prevention of public nuisance, and whether the concerns that have been raised are likely to be attributable to the licensable activity being the sale of alcohol at the premises. You will need to consider the likelihood of the licensable activity itself adversely affecting the promotion of the licensing objectives, which is set out in the agenda pack, and to what degree, if any, provisions to deal with such concerns are within the control of the applicant. For example, the issue of parking and deliveries has been raised. The applicant has undertaken that it will work with, as far as possible, the local authority to try and address the issue of deliveries and the preferred timings for that. In terms of the other parking issues that have been raised by those that have made written representations, you'll note that the applicant doesn't have the power themselves to enforce on-street parking regulations, albeit there are other bodies that do in terms of highways control and traffic enforcement. So you have the discretion to determine this application, having due regard to all the written and oral representations that have been before the panel today, including those written representations which are still live, that are within the agenda pack, but those making those representations are not physically at the hearing today unless they are watching online. You will also consider the provisions of the Licensing Act 2003 and the updated Home Office guidance issued under section 182 of that Act. You will also consider the Council's own statement of licensing policy. You will also consider, which is set out in the agenda pack, the applicant's operating schedule, and also referred to in the agenda pack the mandatory license conditions that would attach to the license that should you be minded to grant it. You will also note the further conditions that have been offered by the applicant, both within the agenda pack and the operating schedule, also that have been offered during the mediation process, and also those additional ones that have been advised to you verbally today. You will also consider the Licensing Act hearings regulations themselves. So the overriding objective for you as the panel today is to determine this application for that said licensable activity, having regard to the promotion of the 4 licensing objectives that are set out in the Licensing Act 2003. Those are the prevention of crime and disorder, public safety, prevention of public nuisance, protection of children from harm. Each application is determined on its own merits. The decision is to be evidence-based. As this is a new premises license, you will need to consider whether the granting of the license is likely to have an adverse impact on the promotion of licensing objectives, and whether sufficient checks and balances can be put in place by the mandatory or additional conditions in seeking to prevent such issues occurring. Whilst some representations have been received and some parts of this hearing have been mediated, others are still live and have not been withdrawn, you need to consider those, including those that are in writing. Those representations, as we've heard, go to the licensing objective of the prevention of public nuisance, as Mr. Dalluta and other those making representations have raised. The issues of concern relate to noise nuisance, they relate to littering, and they relate to parking. As you've heard from the applicants, they've also already offered additional conditions in terms of noise associated with emptying of glassware, and they're proposing that they would be agreeable to a condition not to do that between the hours of 10 o'clock at night and 8 o'clock in the morning. There are also mandatory conditions already for the provision of bins in terms of litter. They've also offered additional conditions in terms of littering checks outside and picking up litter that's emanated from the premises. And as you've heard from the applicant, they're also willing to liaise with the local authority to determine and fix a level of noise, acceptable level of noise from the proposed sound equipment. So you may consider that alleviates the issues of noise. As I said, parking itself is not a licensable activity. It's not, other than the deliveries potentially, it's not within the direct control of the applicant, and there's no direct causal link presently, because this is new premises, as to whether the granting of a license for the sale of alcohol would necessarily cause parking issues itself, because not everyone that's going to park to go to that premises is going to be, for example, drinking alcohol, because they've been nominated drivers, etc., who aren't doing so. You have the discretion, as I said, to determine the application. If you are minded to grant it, there will be the mandatory conditions. You have the option of imposing both, as I said, the additional conditions that have been offered prior to this hearing in the application, in the mediation, and those that have been orally offered today. You also have the discretion to impose any other conditions that you see fit to impose. However, if you are minded to impose any such additional conditions, those must be proportionate, justifiable, capable of being met by the applicant, and appropriate to the promotion of the licensing objectives. You will note, as been said by the licensing officer, there were no objections received from the responsible authorities. There was a comment by Environmental Health in terms of the provision of the number of sinks in the ladies' toilets. That's not, they weren't objecting per se to the application. So in terms of the representations that have been received, as you've heard, there are a number of conditions within the operating schedule that augment the mandatory conditions. Additional ones have also been proposed, which I've already covered in terms of not disposing of glassware outside between the hours of 10 and 8. We've also mentioned about the speakers for the playing of any music shall not be located outside the premises or near the main entrance. The applicant will conduct regular risk assessments on noise levels outside the premises to ensure that noise from music and speech arising from the premises should not be audible outside the premises. As you've heard from the applicant today, notices will be prominently displayed at the exit, requesting customers to respect the needs of local residents and businesses to keep noise to a minimum. Staff will operate and implement a dispersal policy outside at the terminal hour. The licensee will also instruct staff to do regular litter checks and to remove any litter emanating from the premises. As you've heard, all windows and the main entrance door are triple glazed and will be kept closed after the hours of 10 o'clock, save for access. As you've heard, there is air conditioning at the premises. In terms of the live and recorded music itself, as you've heard from the applicant, it's proposed that will simply be to background music to augment the dining experience of the diners. This is primarily proposed to be a high-end restaurant rather than primarily a drinking establishment or a bar. The live music that's proposed, examples have been given of occasional use of a saxophonist or a violinist to accompany the dining experience. As you've heard from the applicant, and in answer to the representation from one person, there will be no resident DJ at the premises. Also, within the conditions that have been offered, I understand that the applicant will make available to nearby residents and to the responsible authorities a telephone number by which any complaints can be emanated to. So essentially you have the discretion ultimately to either grant the licence subject to conditions proposed, including those within the operating schedule, the mandatory conditions, the offered additional conditions. You also can grant the licence subject to any modified or additional conditions should you see fit. You can also grant the licence but exclude any of the licensable activities, or you can refuse the application. You will consider all of the legislation and that it provides for a scope provides a scope for review or revocation as an ultimate sanction should any problems be arise. So there is checks and balance within the legislation should any issues arise, but ultimately it's your discretion to consider the application in terms of everything you've heard and said today. Chair, over to you.
Thank you, Mr. Adams, for that full and detailed information. Okay, that concludes this panel meeting. The panel will now meet in private to make a decision. The decision we reach will be communicated in writing to all parties and published as the minutes of this meeting within 2 working days. When the panel meets to deliberate, the clerk and legal advisors shall be present with them to keep a record of proceedings and advise on points of law. They will take no part in the decision itself. Does anyone have any objections to the clerk and the legal advisor meeting with the panel?
No, Chair.
No, Chair.
No,
Mr.
Chair.
Dalusa?
No.
Thank you for attending today. We will be leaving the room now, and we will return when a decision has been made. You may stay online if you'd like to hear the verbal decision, which we will reach as soon as we are able. Thank you very much.
Thanks.
Thank you.
Thank you.